Sometimes the story starts with something super simple, something we can all relate to, like just wanting to fix up your yard. But for one guy in Scottsdale, Arizona, this very normal idea to replace a patch of dirt spiraled into a full-blown, year-long legal war with his homeowners association.
I mean, just listen to this quote from the homeowner's lawyer. It paints such a clear picture, doesn't it? We're not talking about someone wanting to change a perfect green lawn. We're talking about bare earth. This quote really gets right to the heart of the frustration that kicked this whole thing off.
And this whole saga brings us to a huge question. It's one that a lot of people might face. Can your HOA really block you from putting in something like water-saving artificial turf if their own rulebook doesn't even say you can't? It's a fascinating issue pitting homeowner rights against community rules, and as we're about to see, one set of rules against another. So let's dive in. Okay, so let's meet the man at the center of all this. His name is Carl-Mitchell Smoot. He's lived in the Los Reyes community in Scottsdale since 2002, and he basically looked at his front yard one day and thought, yeah, it's time for a change. Now you've got to hear his plan, because on the surface, it sounds fantastic. He hires a professional designer, he wants to put in high-quality artificial turf, use plants that are already on the HOA's approved list, and, get this, especially for Arizona, he wants to switch to a drip irrigation system to save a ton of water. I mean, that sounds like a win for everybody, right?
Well, spoiler alert, it was not a win-win. It turned into this long, drawn-out fight. He submits his plan in January 2022. By May, he gets a final no from his HOA, and it then takes until April of the next year, more than a year later, to finally get a legal decision. Just wild.
So you're probably wondering, why the big fight? What was the major holdup? Well, it all boiled down to a classic HOA disagreement, but this one had a really interesting legal twist. It involved two different and seemingly conflicting sets of rules.
So, to get this, you first have to understand what a sub-association is. Think of it like this. McCormick Ranch is the giant umbrella, the master association for this huge community. Los Reyes, where Mr. Smoot lives, is just one small neighborhood of 55 homes inside McCormick Ranch, and it has its own separate HOA. This two-layer system is the absolute key to this entire case.
And right here, this is the conflict in a nutshell. The local Los Reyes rules, totally silent on artificial turf. They just mention the growth of turf, which the board took to mean only natural grass. But the Master Association's rules for the whole McCormick Ranch area, they are crystal clear. They explicitly permit high-quality artificial turf. This is the contradiction that landed everyone in a hearing.
So armed with this pretty glaring contradiction, Mr. Smoot and his lawyer head to an administrative hearing, and they lay out a really clear, logical case, using the HOA's own documents against them. His case was built on a couple of really strong pillars. First, just because the rules are silent doesn't mean it's banned. But here's the bombshell, the real kicker. A clause in the Los Reyes documents, Article 9.4, that literally says their rules shall not contradict the Master Association's. Game, set, match, right? Since the master rules allow turf, the sub-association can't just ban it. Plus, his lawyer pointed out that homeowners pay for their own water, so it's a shared maintenance duty, not just the HOA's job.
But of course, the HOA had its own arguments ready to go. They weren't just going to lie down. Their case was built on a specific state law and, you guessed it, a defense of the neighborhood aesthetic.
The HOA's big argument hinged on an Arizona law that says an association can ban turf in an area it's required to maintain. They also argued that artificial turf would just ruin the uniform, harmonious look of the neighborhood, where all these natural grass lawns kind of flow together. The board president even said it would chop up the neighborhood.
So there you have it, two completely different interpretations of the rules. The homeowner is focused on the hierarchy of the documents, while the HOA is focused on state law and that community vibe. It all came down to administrative law judge Sandra Vanella to make the call.
And the judge's logic here was just so methodical. First, she took on the HOA's main defense about maintenance. She decided that since the homeowner pays for water, it's a shared duty. That really weakened the HOA's argument under state law. Then she looked at the rules and landed on the exact same critical point as the homeowner. That shall not contradict clause is king.
So the final verdict was completely unambiguous. The judge ruled that by denying the plan, the Los Reyes HOA had actually violated its very own rules, a huge clear-cut victory for the homeowner.
And the win wasn't just on paper.
The judge ordered the HOA to pay Mr. Smoot back for the $500 filing fee he had to pay to even bring the case. It was this tangible symbol of the court's decision, and really the final chapter of this year-long battle.
Okay, so what a story, right? But what are the bigger lessons here? What can any of us who live under an HOA take away from Mr. Smoot's fight?
Well, there are three really big takeaways here. First, the hierarchy of rules is everything. If you're in a sub-association, those master association rules can be your secret weapon. Second, remember that silence isn't a no. If your rulebook doesn't explicitly ban something, you might have a really strong case. And third, that whole "we maintain it" argument can fall apart pretty quickly if you're sharing any of the costs or the work. At the end of the day, this case was never really just about artificial turf. It was about this fundamental clash, this tension, between an HOA's desire for everything to look the same and a homeowner's right to improve their property and, hey, maybe even conserve some water. This ruling gives us one answer, but it leaves a much, much bigger question for planned communities everywhere to think about.